When you think about a legal dispute, you probably picture long, expensive, and honestly really stressful courtroom battles. But what if there was another way? Today, we're going to break down a really powerful alternative, the Bombay High Court's mediation scheme. It's a system that's built to find resolutions, not just winners and losers. Look, nobody wants to face a legal battle. The whole process can feel like this endless war, just draining your time, your money, and your energy. But here's the thing. The goal isn't always to fight. It's to find a solution. So we're going to explore a path that actually prioritizes resolution over confrontation. So here's what we're going to cover. We'll get into what court annex mediation actually is, figure out if your case might be a good fit, walk through the entire journey, break down the costs, which you'll want to hear, and then wrap up with why all of this really matters to you. All right, first things first. What is this thing called court annex mediation? Let's unpack how this process really can be a better way forward. Okay, at its heart, mediation is basically a structured negotiation. But here's the key difference from a courtroom. The goal isn't to have one side win and the other lose. Instead, you have a neutral expert, the mediator, whose only job is to help both sides find some common ground and build an agreement that everyone can live with. It's all about collaboration, not combat. And this is absolutely crucial. This isn't some informal chat happening in a back room. It's an official alternative, guided and supported directly by the court system. That's what gives the whole process its structure and, frankly, its power. And this isn't just a nice idea, it's baked right into the law. The Code of Civil Procedure says it loud and clear. A judge can look at a case and decide on their own to send it to mediation. But even more importantly, you or your lawyer can ask for it. This means you actually have a say in choosing this more collaborative path. So, of course, that leads to a huge question. Is mediation the right fit for your case? It's definitely not a one-size-fits-all solution. So let's look at which kinds of disputes are a good fit and which ones, well, which ones usually aren't. So, as a general rule of thumb, cases that are really well suited for mediation are the ones that involve personal or business relationships. Think about things like business contracts, family disputes, or property issues. On the other hand, cases that usually need a definitive final ruling from a court, like election disputes or serious criminal charges, those typically aren't a good fit. Let's dig a little deeper here. You see a common theme, right? Family disputes, disagreements between neighbors, issues between a landlord and a tenant. Why are these so perfect for mediation? Well, because in these situations, saving the relationship is often just as important as the final dollar amount, and a negotiated settlement can do that in a way a court verdict almost never can. And on the flip side, some cases just have to stay in the courtroom. It makes sense, right? You can't just privately negotiate the result of a public election or a serious criminal offense. These things need the full authority and the investigative muscle of the judicial system to come to a legally binding public judgment. Now, this is super important to remember. These lists are just guidelines. They're not rigid rules. At the end of the day, a judge is going to look at the unique facts of every single case before deciding if it's right for mediation. It's not a rubber stamp. It's a careful decision every single time. Okay, so let's say a judge looks at your case and refers it to mediation. What happens next? Let's walk through that journey, which is really a trip from the formal courtroom to the much more collaborative conference room. The whole process is really clear and structured. It all starts with the judge's referral. Then a trained mediator is appointed to your case. The real work happens in the mediation sessions, which can be in person or even online. If you and the other party reach an agreement, it gets written down and signed. And the final step? The mediator just sends a simple sealed report back to the court saying only whether the case settled or not. That's it. This brings up a really good question. I mean, who exactly are these people guiding you through such a sensitive process? Are they actually qualified? Let's take a quick look. So, the mediators are drawn from a panel of court-approved experts. They might be individuals who have specific legal qualifications. They could be from specialized mediation institutions, or they could even be judges who've gone through dedicated training. The main takeaway here is that you are always working with a qualified, vetted, and totally neutral professional. And what about speed? This is honestly one of mediation's biggest selling points. The whole process is designed to be wrapped up within a standard timeline of just 60 days. Just think about that, 60 days. Now, compare that to a court case that could easily drag on for years and, well, the benefit's pretty obvious. Okay, now for the topic that's on pretty much everyone's mind when they get into a legal dispute. How much is this going to cost me? Let's look at the huge financial advantage of the Bombay High Court scheme. All right, here's the best part. The entire scheme is built on the idea of accessibility. It offers mediation that is either pro bono, which just means it's completely free, or it has a fixed, predictable cost. This is designed to get rid of that constant fear of unknown, spiraling legal bills that you get with traditional litigation. And when there is a fee, the typical maximum is just 10,000 rupees. And get this, that's for the entire process, start to finish. When you weigh that against the potential cost of a long court battle, I mean, the financial advantage is just massive. And this is so important. For some of the most sensitive and difficult cases, mediation is always free. This covers all matrimonial and child custody disputes, issues between employers and employees, and compensation claims. The whole point is to make sure that in these really critical areas, nobody is blocked from getting justice just because they can't afford it. And on the rare occasion a fee does apply, it's almost always split right down the middle, shared equally by the parties. It seems like a small detail, but it really reinforces that fair, collaborative spirit of the whole process. Everybody has an equal stake in finding a solution. So let's pull all of this together. We've talked about the what, the who, and the how. But now let's get to the most important part. Why does any of this matter to you? What are the real world benefits here? Okay, let's just recap the real power of this approach. First, it's way faster. We're talking a 60-day target instead of potentially years. Second, it's incredibly cost effective since it's often free or has a very low fixed cost. But beyond the time and money, it's truly empowering. You and the other party actually control the outcome, not a judge. Everything you discuss is completely confidential and private. And maybe most importantly, it's way less adversarial, which means it can help preserve the very business or family relationships that a nasty court battle can so easily destroy. You know, it all comes down to a fundamental shift in how we look at conflict. When you're facing a dispute, maybe the most powerful first step isn't to gear up for a long fight, but instead to create a genuine opportunity to just talk.